reviewing the billing practices, the contracts that the various outside counsel had, and I pulled up here one section of Mr. Wade's bill for the really early on in his involvement in the case. As I recall, it began on November 1st of 21, so this would be out of his first bill. I see on November 5th, prepare case for pretrial, 24 hours on one day. What do you make of that?
I mean, I thought it was astonishing that, you didn't sleep for 24 hours. I've been to trial. I'm sorry. I've been to trial and had to work long hours, but 24 straight. But we did question him about that at the hearing, and he said that that's when it was concluded. So how he explained it was November 5th is when the work was concluded. And so he had done that work up until then, and that he only billed when it was concluded. So he said that the 24 hours, who knows when it spanned, but that how he billed was
Would have had to
concluded.
be between November 3rd and November 5th, though, right? So it had to be on the 4th and the 5th, 12 hours a day?
It had to be.
At least.
And, the other thing that I noticed with this is prepared cases for pretrial. At this point, it says anti-corruption unit. His two law partners are the conflict lawyers for the anti-corruption unit. So you've got it's like my husband couldn't represent someone who's adverse to me. Like, my husband is my law partner. He can't be doing privilege review on a case I'm prosecuting. So he's consulting on anti-corruption cases for the DA's office, where his two law partners are doing the privilege review at the same time. That plus the 24 hours are the two things that really struck out to me.
So, but the only role he had was this prosecution of this election fraud.
Yes. Okay. Yes, the only role.
Okay. So when it says anti-corruption, that's the corruption. We're looking at election interference.
Yes, he's never worked on any other case.
All right. Let's see that other bill there, Senator Dolezal. All right, so here's another one, if you can see that okay. This is the one we put up earlier. It looks to be much more specific date-wise anyway than just, those 24-hour chunks like that. Okay.
Right. I mean, it's more specific, but it doesn't say what, like, just for example, team meeting and argument prep. Argument prep for what? I mean, normally when we do bills, we would say, argue motion to dismiss or argue whatever the motion is. Research, what are you researching? Researching statutory privilege, whatever it is.
Yeah. Now this one, he shows date ranges when it's over multiple days. Like down at the bottom, 426 to 427, 18 hours, right, if I'm reading that right, or 16 hours. But on that previous one, he just has one date, 24 hours.
Yes.
Okay. And you say these are approved by Fonnie Willis. By contract, she has to approve these billings.
Yes, she does.
Okay.
And those are approved by her. So if there were any questions, and as a lawyer, when we submit bills to clients, they regularly question, and I know when I've done appointed work, they regularly question that as well. You have to list exactly what you're in court for, exactly what you're drafting. You can't just say prepared cases. You've got to say, what did you prepare? What did you draft? So, I mean, the county, in Cobb County, for example, they make you actually attach motions. If you do like an appeal or something and you're billing for that, you have to actually attach it to prove that you did the work. I did go back at the break, though, and I have an answer to one of your questions earlier. I just wanted to clear up. You had asked me when the special purpose grand jury had convened. I looked. The state filed a response. So this is D.A. Willis's response that was filed on February 2nd. They wrote on
this response to your motion to disqualify?
Yes, sir. Okay. Response to my motion. On page 13, they wrote, shortly after his appointment in January 2022, District Attorney Willis petitioned the Chief Judge of the Superior Court to convene the Superior Court judges to consider her request for the special purpose grand jury, to conduct an investigation into the facts and circumstances relating directly or indirectly to the possible attempts to disrupt the lawful administration of the 2020 elections of the state of Georgia. And they attached that exhibit. So you had asked me earlier when she petitioned. So it was, in their own words, shortly after his appointment.
Okay. So this whole the cases are about attempts to disrupt, because obviously Georgia certified Biden as the winner, and he got inaugurated, that following January, and this is years later we're having this whole investigation.
Yes, attempts. And my client specifically is charged with attempt and conspiracy. So he's not charged with actually doing a specific act. He's charged with conspiring and or attempt, depending on which section you're talking about in the charges.
Some of these itemized statements show drafting.
Yes.
Did Mr. Wade draft any documents to your knowledge or
No.
prepare any legal documents at all?
No, not that I'm aware of. And that
Did
would
he
be
sign any pleadings as if he was the drafting attorney?
No, and he's not the one that usually files them. Will Wooten is the one that usually does the filing. There's two other prosecutors that also do it. Alex, and I don't want to butcher his last name, starts with a B, but he does it, and then Grant Rude. Anna Cross has also filed pleadings, but not Mr. Wade.
In your review of all of his billings, did you ever see where any of his time or bills were cut or reduced by whoever was reviewing them and approving them, either Ms. Willis or her deputy?
No, I never saw any questions. And her response, or their office's response, doesn't indicate that that was ever done either.
And your experience when you were doing like your public defender work, that you were reviewed and they cut your time?
Oh my gosh, yes. Yeah, when I first left the public defender, I had a couple clients that were in the appeal process, because at that point I was in the appeals division when I left, and I didn't want their cases to linger, and I didn't want a new lawyer to have to kind of just pick up right when they were going to the appellate courts. So I kept some of them. Some of them the judges appointed me, and so I would be paid, I think it was $50 an hour, $45 an hour, something like that. And then some I just took pro bono, but I had to get those bills approved. I mean, and they were regularly cut.
On Mr. Wade's contract, he was allowed to bill, he was capped, he could not bill more than $35,000 in any given month?
Yes.
Yeah.
And that was not, so the original contract before the special purpose grand jury was started was a lower cap. This was the cap for the majority of his work during the special purpose grand jury and then now. So he had a contract November 1st, 2021 up until October 31st, 2021. And the cap was lower for that. Then there was a period of, I think it's 15 or 16 days where he did not have a contract. Which also happened to be one of the times they were out of town. So they re-upped the contract November 15th, and then it had a cap. But the cap was significantly higher.
Okay.
I mean, I don't remember the first cap, but it was not $35,000.
Here is a document you produced. I think you prepared this summary that shows all the payments that he received.
Either I did this or this might have come from Fulton County Purchasing.
All right.
Okay.
So that was produced to you from Fulton County as
Yes.
all the payments he received?
Yes, this was produced from Fulton County, yes.
And what's the total? Is that just, my eyes aren't so good. That looks like 22 all the way through 23.
Yes, 22 through 23. So so his first bill would have been paid in January of 2022. So he billed for time in November, December, and then you see those two bills. And so those were $15,000. I believe that was the cap. So in
Right.
January, he was paid for $15,000 for work in November, and then in December, he had work totaling $15,000, and he was paid for both of those in January.
That's why there's those top two invoices for $15,000.
Yes, that's why there's those top two invoices. And they produced some other documents to me as well that showed which funds they came out of. So I was able to track which ones came from state seizure money and then which ones came from county general fund.
And that was all before this grand jury was even approved.
The grand jury was not approved until June of 2022.
Okay, it was requested in January.
It was, and I just looked that up at the break. So it was requested in January. It was approved in June. The order, actually. But what happened was they started picking, so it looks like they started picking the grand jurors on May 2nd of 2022, and they actually started hearing evidence June 1st of 2022.
Okay, so lots of this time was way before he would have been having to question any witnesses or attend grand jury hearings or anything.
Yes, he could not have attended a grand jury hearing until at the earliest May 2nd.
You were talking about the experience and expertise of the three outside, I'm gonna call them outside counsel, because they were not direct employees of the DA's office.
Correct.
Had Mr. Wade ever tried a felony case, prosecuted a felony case before this, to your knowledge?
No, that he has never prosecuted a felony case. And I asked his law partner that, who had been his law partner for some time, that he had never prosecuted that. I also did some independent research in the metro areas where I knew that he had worked in Cobb County, so I looked to see if he had ever been filed as a prosecutor in Cobb County for felonies, and he was actually just a solicitor, and solicitors is, because you'd said not everybody may understand the difference between solicitors and district attorneys.
We've got an ex-solicitor on this panel, so don't say anything negative about him.
So he can tell you all about it.
They prosecute misdemeanors only, right?
Yes, and in Cobb County specifically, they prosecute misdemeanors, yes.
Okay. It looks like he's pretty much hitting the maximum that he was allowed to under his contract?
Yes, most months he did.
Okay. And this is through that block billing that was not specifically itemized exactly what he was doing or how much time on each task?
Always block billed.
Okay.
He never itemized bills, never was specific.
What were the caps for the other two special counsel? Were they also limited? I assume you've received their contracts, or did they have a written contract?
They did. So they had written contracts, and I do have those, and they did have caps. They were significantly lower than Mr. Wade's. They do not currently have contracts, and I just found that out at a hearing because we had asked for that. We had asked for it in open records, and then I had subpoenaed it as well. Pretty much every subpoena I filed for the hearing, the state filed a motion to quash, including this one, and Ms. Cross was at the hearing, and she said, I can just tell you right now I don't have a contract. So I had thought, I was under the impression that they just weren't giving me that contract. I had no idea that they just didn't have one. So apparently right now, Mr. Floyd and Ms. Cross don't have contracts.
Do you think that was intentional so that they don't have to disclose how much they're earning?
I think it was sloppy.
Okay. Does Mr. Wade have a current contract?
Yes, he does. I also think that, I think it may have been, I don't know if it's disclosure, but I can tell you that they've changed, since I started looking at this, they've changed what they put on the public documents. I used to be able to go to Open Checkbook and see every time he would get a check, and since I filed this, none of them have come up. So I don't know if he's not being paid anymore, or if he hasn't filed any invoices, but the invoices are due, I believe, 30 days after. So, you know, they regularly came up, but now all of a sudden they don't.
Okay. So eventually you sought to disqualify Ms. Willis from serving as counsel and prosecuting Mr. Roman's case.
I did.
Okay. Can you pull up that motion? That motion was filed here in January, I think it was January 8th of 2024.
Yes.
What was your motion to disqualify based on?
It was based on a number of things, but it was based on mostly the fact that Miss Willis and Mr. Wade had a romantic relationship, and they had been traveling, and he had been paying for a lot of that travel. So there were a couple different things. She had not followed the statute. So the statute I referenced earlier, 15-18-20, said that you had to have county approval. She didn't have that. So that was one thing. There were also—
You had figured that out through your financial records?
Yes, I had figured that out through my financial records, through open records, through reviewing all the Board of County Commissioners. And I actually, to that motion, I attached, just on this issue, I actually attached a document showing how independent special counsel would normally be appointed, or I'm sorry, special counsel, because I found one where, and I think it's exhibit, let's see. It's exhibit J. I found one where Fulton County had actually been asked to approve a line item for an independent contractor agreement. And so this, I used it as an example of what normally would happen.
Was that for an attorney?
It was for an attorney.
So she's saying in pleadings now that she's not required to get county approval, but in the past, for people other than Wade, she had gotten approval?
This is actually the county attorney. So
Okay.
This document is the county attorney. I do not believe she's ever gotten approval for anybody. And her filing said doesn't. I mean, her filing, I at the break I was looking at it. I mean, she said that that I incorrectly contend that the appointment exercised by, and in parentheses, a state constitutional officer must be followed by an approval of the local government's Board of Commissioners. And she says over and over again that I'm just wrong, that she doesn't have to because she's a state constitutional officer. So that was their position, that she doesn't have to.
So is that one of the grounds for your motion to disqualify these, let's just call them financial irregularities, that she had not complied with the state law or county policy of getting prior approval?
Yes, that was one of the primary bases. But then I also reviewed case law and saw, the conflict of interest. And, our motion, the theory, basically just to sum up the motion, is that essentially he's getting paid all of this money and they're not going through the proper procedures. And I go through it in the motion. I talk about how he didn't file an oath, which is rare. I'm one of those.
Didn't file a what?
He didn't file an oath of office. Yeah. And I'm one of those people that I always, when I first start a case, I always make sure that everything is all the I's are dotted and the T's are crossed. So I always pull that. Anytime I've only ever had special counsel twice, and it's been people who were not paid, who were district attorneys in other jurisdictions who took the case on, which is the normal process in the state. But I've always pulled that just to see that they're sworn. That's something that's important to me. And I couldn't find it, so I did open records to the probate court, to the Superior Court, and there was no oath of office filed.
Sworn for the special assistant district attorney?
Yes. If you're going to be inside of a grand jury juries are highly regulated. I can't just go in a grand jury. None of us can just go into a grand jury. So you have to be a sworn officer of the state to actually be in there, particularly to present evidence. And so I wanted to see if he had taken an oath. And that's something that, you would file. It should be publicly available, not something that's really, highly contentious or secret. And there wasn't one. So, once I learned that, I was like, why are they not filing an oath? This is odd. There's no public approval of these contracts. There's no oath of office filed. This is different, what's going on. We later found out that he had taken an oath, but nobody had filed it, and the law requires, there's a statute that requires you actually file it.
I have looked at that. So the statute for a district attorney, their oath, when they are sworn in that position, says, I do swear that I will faithfully and impartially and without fear, favor, or affection discharge my duties as district attorney and will only take my lawful compensation.
Yes.
So help me God. Did Ms. Willis sign her oath that swore she would not take any unlawful compensation?
Yes, she did that, and then she also filed some disclosure forms that are required. There's financial disclosure forms that Fulton County requires that you file every year, and you have to disclose if you've received any gift over $100. So from anybody doing business with the county. And Fulton County is I used to be a Fulton County employee. They are very strict on those types of things. So anytime there's anything that could be construed as a gift over $100. And I've gone to lunch with prosecutors before who wouldn't let me pay for lunch because they're like, what if it's over $100, So people do take that pretty seriously.
So that would apply to Ms. Willis would not be allowed to receive gifts from whom?
From anybody who was, and I actually believe I attached it as an exhibit. It's basically anybody who is doing business or seeking to do business with Fulton County. Okay. So, and it's one of those.
That would include Mr. Wade, obviously, then?
Oh, definitely.
Okay.
And that makes sense because that's one of those provisions that's supposed to, be guarding against honest services.
Like anti-kickback statute.
That's exactly what
Hire somebody as a vendor and they give you gifts in exchange.
Yes, and so they require that you disclose that every year. It's signed under oath. You have to file it with Fulton County.
So how'd you learn about this relationship between Mr. Wade? I think this has been acknowledged now by both parties, correct?
It has, yes.
It's a dispute as to when it began, but it's acknowledged that they had I don't know if they still do, but at least had a romantic relationship.
Yes, that's
How'd you figure that out? How'd you find out?
So at first, I knew Mr. Wade and I knew Ms. Willis, and a lot of people in the community were a little surprised to see Nathan, Mr. Wade handling this case. It was just, a lot of people said that, and so a lot of people were talking about that, and it was kind of surprising, because it's not really, he does a lot of law practice, but this isn't what you would imagine him doing.
Did you ever see him have other billings? I mean, how do you have time to represent anybody else when he's billing, 24 hours a day to Fulton County?
He had other people working for him. Like, he had a law student working for him for a while, and then he had a first-year associate. So I'm assuming that they would probably do whatever other work he had.
Did you ever look at his calendar? Did you have access to that to see if it matched up?
No, I didn't have access to his calendar, and I didn't have access to their text messages. I mean, I was able to get his geolocation data through subpoena, but the one thing that really struck me is if I was accused of something and I was saying I didn't do it, I would download my phone. They have a system. It's called Celebrate, and Fulton County pays for it. City of Atlanta pays for it. It's literally a system that you can hook your phone into. I have an investigator that has it, and I have my clients do it all the time. You hook your phone up, and it can find deleted text. It can find everything, and you can limit it. You can say, I only want text with this person. So, if I was being accused of having an affair with someone, and I said it didn't start until April, and someone else said it started in October, the easiest thing to do is to, download that phone. And for privacy concerns, you can file it under seal, but you could easily narrow it down and say, I want this timeline. I want all of our texts from, November 2021, and it would easily tell whether or not they were romantic in nature.
Before I leave the billing issues, did you ever compare Floyd and Cross's bills to Wade's to see if they were meeting together, like there was that meeting with teams or what? Were they billing for the same meetings as well?
So I looked at that. One thing is we don't have most of Floyd's. So Floyd has not billed in quite some time. So I didn't have his to compare, but I did look at Anna Cross's. The one day that I remember looking at was when they were in federal court to see, because so Ms. Cross was the one actually litigating in federal court. But Mr. Wade was sitting there with them at counsel table, and they both billed for that. I wanted to see if he billed for time that he was sitting in court waiting, because I know in Cobb County, for example, with appointed work, if we're sitting in court waiting, we can't bill unless we're actually doing something. Like, they won't pay for two people to sit there. And so I wanted to look at that. But they were both there in court that day.
What about the teams meeting where he billed for? Were either of them involved in that team, since they're also outside special counsel?
No, they were not. So all of those people were people who would not have itemized that.
Okay.
Employees.
Right. Back to your uncovering the relationship.
Yes.
How did you figure it out?
So Terrence Bradley was Nathan Wade's law partner originally, and he was also his lawyer in the divorce. I did not at the time know that they had filed for divorce. I knew Nathan's wife. I knew both of them historically from Cobb County. I mean, people knew them in Cobb County. Mr. Bradley actually called me after an article. We were looking into the financial irregularities. We're looking into how much money had been paid, because everybody in the case was kind of like, what, why do you have special counsel?
Case?
On this case, yeah. Like,
was
why
Bradley still a partner with Wade at that time?
He was not. There was testimony that their partnership ended in summer of 2023. So it had just ended, is my understanding. And it's kind of unclear, like, what month. The testimony is very unclear as to when they actually, I have when they dissolved. I think it was September, but it's very unclear as to their partnership. And I will say their partnership was a loose partnership. They had a partnership with the bar, but they all had separate legal entities. So each of them were filed as the law office of Terrence Bradley, law office of Nathan Wade. They had some joint bank accounts, but then they had some separate bank accounts. So I don't really know the exact structure. It was a very loose type of organization. But they were working together. And so Terrence actually called me. He had seen an article where I had done open records with another lawyer, Manny Aurora, and we had uncovered how much money everybody had made. The news had gotten wind of that, and I later learned that the news had open records to get all of my open records. So every time I would get something, the news would get it, because I wondered how that happened. But so that somebody published that, and I had done some more open records. And Ms. Willis actually called Mr. Bradley when I did these open records and said, they're looking into us. And he called me because he was worried about it. And so we had a conversation, and he actually asked me, do I need a lawyer? What's going on? What are you investigating? What's the parameters of this? And we had a conversation, and I said, well, my interests are different than yours. I represent Mr. Roman, so I can't advise you. That would be a conflict. He asked if John, my husband, could, and I said, no, that's a conflict too. If you feel like you need somebody, you need to talk to someone else. At the time, that was early in September. I had court in Cobb County, and I ran into Mr. Bradley. I was in Judge Harris's courtroom. I think it was either September 11th or 13th. I checked my calendar a week or so ago, but it was one of those dates. And I was taking a plea in front of Judge Harris, and Mr. Bradley was also there. Another lawyer who ultimately represented Mr. Bradley at our hearing, B.C. Chopra, he was there in court also. And then a friend of all of ours who's a district attorney, his name is Bert Cohen, he was taking the plea with me. And Bert and I have known each other for a long time. Terrence, BC, everybody's known each other for a long time. We were all sitting in a conference room attached to that courtroom, waiting for the pleas, chit-chatting, took the plea, went back in, and Mr. Bradley essentially went through the whole thing and said, well, this is what's really happening. I had a notepad and I took notes on all the things to ask for open records.
So what did he say was really happening when he said this is what's happening?
He said that they met at a judicial conference before, he was very specific that it was before she became DA, because that was one of the things that he couldn't remember when the judicial conference was, but he knew that it was before she became DA.
When did she become DA?
She became DA in, it would have been January 2021.
Okay.
So she became DA January 1st, 2021, but she had a transition team leading up to that. So, and Mr. Wade was in charge of her transition team. So Mr. Bradley told me all of that. We met for about an hour. Said that they had been together. They met at this conference. Nathan was still married, and Mr. Bradley was upset because of what happened in the divorce. He was upset because they were still married, the Wades were still married, and he essentially just left her after meeting Miss Willis and dropping the kids off at college. So.
And Bradley was Wade's attorney in that divorce action you're talking about? Okay.
Yes, I didn't know that at the time.
But they were law partners.
They had been,
Okay.
yes.
Okay.
And I actually don't know if he was still his attorney when he talked to me. I don't know if he was or not.
All right.
Because at some point, Mr. Wade represented himself, and then he hired a different lawyer. So I didn't know anything about the divorce at
Okay.
that time.
So Bradley did not like the way Wade had treated his wife,
He did not.
but he
did not.
represented him.
He did not like the
Okay.
way he had treated his wife. He didn't like what was happening in the divorce proceeding, yes.
Okay.
And, I mean, I remember specifically him saying, I handle my business, things like that. Like, that I don't leave my wife without alimony. Because this, and we talked about it. I mean, Miss Wade had been a stay-at-home mom for, they'd been married almost 30 years. And literally it was right after they dropped their youngest off at college that he said, move out, And so we went through, I was obviously interested in, wait, what? What's happening? Walk me through this. And so he was telling me about the access cards, that Mr. Wade had access cards, telling me about the contracts, told me about their contract, that they had that Nathan had brought them the contract for the first appearance hearings. They had a contract for that. We didn't talk about that yet. That they had the contract for the taint work, and then ultimately that Nathan was hired as the attorney on this case. That they had been dating before, and he told me, they met at hotels. He would go to her place. And I remember him saying, you need to find her bestie who they had a falling out. That's the person whose condo it was that they would meet at. And
did you later determine who that bestie was?
Yes, it was Robin Yeardy. It was not until sometime later that I determined that. It was very difficult to determine who that was because he did not remember her name.
But he knew her by sight?
He did.
Did he later confirm to you or identify who she was?
Yes. So I had sent him a couple pictures or showed him a couple pictures of some other folks or
this
names.
Was in January of 24, right
Yes.
before your motion?
It
Okay.
was. It may have even been after I filed the motion. It was around the time. It was either before or around the time, but it was in January. I had gotten some open records requests from the DA's office. They had a contract. Yep.
We just put on the screen
There it is.
some
Perfect.
of the text messages that you produced to us.
Yes.
This
yes.
is from your phone.
It is. And so
you're talking to Terrence Bradley, I see over there on the left.
Yes, and so when you see on the 14th, that one that's right in the middle that says file attachment with MIME type, that is a picture of her. So it doesn't show up on this, but it's actually, there was a picture of
So
Miss
while
Yeardy.
you're texting, you're shooting him a picture to see if he can identify Robin Yeardy.
Yes, yes.
Did he identify her?
He did, yes. He said, yes, that's her, that's the East Point. And he thought the apartment was in East Point. I later found out it was in Hapeville, but those are very
Right.
close in close areas.
So he knew they would meet at that apartment?
He did, yes. He knew all
Okay.
about it. And it was hard to find Miss Yeardy. What happened, and she was Robin Bryant, and then she got married and was Yeardy. I did an open records request for a contract that the DA's office got. It's called critical mention. She has I guess he's an attorney, but he's sort of in charge of communications. His name is Jeff DeSantis. Right after Ms. Willis had opened the investigation in this case, that same week, he contracted a company called Critical Mention, which is a media monitoring company. They put a dollar figure basically on your media presence, and they give you these analytical reports. And they say, hey, you did great on MSNBC. That's $1 million worth of, stuff for your brand. The Fonnie Willis brand is doing well, or this phrase is doing well, things like that.
She had an employee in her office that was responsible for promoting her image, her publicity?
She had a publicly funded contract for this. So Jeff DeSantis contracted or called this company, and it's in the emails. I think I provided those as well, but contacted Critical Mention and said, we need to hire you to do media monitoring. And it was the same week that she had sent the letter to Raffensperger and Kemp about this case. Said, we need to have a contract to do media monitoring. Got $10,000 approved, paid $10,000 for a year contract for an annual contract.
Who approved that?
Jeff DeSantis' email said the county approved it, and his emails indicated that it was hard to get approved, that he had to really push, I think is what he said. There's some language to that, but the county paid for it.
Do other DAs do that?
I'd never even heard of media monitoring. I didn't even know it
Yeah.
existed. No. It was very shocking. But so I got some of the emails about this media monitoring. So I did open records, and again, once I got them, they shut me down and wouldn't give me anything else. But so these emails have attachments, they're PDFs, and you can see in the emails the hyperlink to them where you can actually see the analytical reports. That's what I wanted to get, and obviously nobody would give those to me. But these emails showed a trail where two people in her office, so Ms. Willis, Mr. DeSantis, and then Robin Yeardy, were the ones that had access to this Critical Mention profile. It's a platform that you can log into and see, how am I doing in the media.
What was Robin Yeardy's role in the DA's office?
She was a liaison between the news organizations. So she said that when CNN, MSNBC wanted her on, they would call Robin and she would coordinate it. She would do her hair and makeup, and then she would coordinate her interviews. But so how I found Robin was I'm going through these emails, and all of a sudden I see an email from Mr. DeSantis saying, take Robin off of this account. She's no longer with the office. And I was like, oh, I wonder if that's her. And so I found a picture of her, and I asked Terrence, is that her? Because I found out she had been fired or been let go or had quit or whatever it was. And so that's how I was able to figure out who Robin Yeardy was. Then we were able to run her, run her information, get an address, and that's how we were able to narrow down where this Hapeville condo was.
Okay, so that's where basically Miss Willis and Mr. Wade would meet
Yes.
for their relationship.
Yes.
Yeah.
But Mr. Bradley told me at that first meeting that they would meet at hotels. He told me about a lot of travel. I mean, he detailed, he detailed a lot of stuff. He said that they traveled to Texas, they traveled to Florida, a lot of different travel. He said Belize. He specifically said Belize, a cruise, the Bahamas, things like that.
And you were later able to verify that through other subpoenas or open records requests or whatever?
Yes, I was. I was able to, I subpoenaed bank records, I subpoenaed credit card records, and then I actually subpoenaed the travel agencies that Mr. Wade used for some of those trips. He used, two of the cruises that they took, he used a travel agency. So there was a cruise to the Bahamas, I got through a travel agency. There was a trip to Aruba that I got through the travel agency. And then there was another cruise, I think that one's to the Bahamas also, that I got through a different travel agency. And then his credit cards are the ones that showed all the Belize trips.
And they showed that he was buying the tickets for both himself and Miss Willis?
Oh, yes, the credit card statements. So because I guess he used a travel agency, his credit card statements actually had her name and seat number and all that on it.
Okay. And
So, there was no disputing.
Clear it was paid for by him on his credit cards?
Yes. Oh, yes.
Is
crystal
this
clear.
the document you gave us from the Capital One there?
It is, yes. And there you can see, so Clara Bowman is Mr. Wade's mom. So this was the cruise that happened October 31st, around that date. Mr. Wade paid for Miss Willis, Mr. Wade, and then his mother's plane tickets, and then also their cruise receipt. I think that one was Royal Caribbean.
Okay. So your summary here showing the trips, we know that in late October they took a cruise to the Bahamas, and this is from his financial records. He paid for this for both tickets?
Yes, this is from his financial records, and I tried to be, there were a lot of Ubers and things like that. I did not include things like that,
Yeah.
that I wasn't positive. I wanted to be under-inclusive, not over-inclusive.
Right. And then you show the trip to Aruba, another one to Bahamas, one to Belize, one to Napa Valley, California.
Yes.
These are all from October 22 up till May of 23.
Yes.
Okay. This is a document you produced to us?
Yes.
This summary, or is this something we prepared?
No, it's a summary.
Okay. And so you discovered that and verified its accuracy through these credit card receipts, et cetera?
Yes. Oh, yes.
Okay. Do either of them deny these trips occurred?
No, not at all.
And so is this the impropriety, the financial impropriety of getting financial benefit from the job, that he's paying for her way on these trips with money
Yes.
that she's paying him and approving?
This is what I would call undisputed. You know, some of the other stuff on his credit cards, it looks like there's trips to Charlotte and Florida and other things like that. But this is what we could undisputed say was with Miss Willis.
So back to you're a good investigative reporter here. So you have heard these rumors, and now Mr. Bradley, just by almost happenstance, you're with him in court.
Yes.
And he spills the beans on it and verifies it. Then you go get the documents to prove it's accurate.
Yes.
And you identify year to get him to say, yeah, that's the woman whose condominium they would go to?
Yes.
Okay.
And you know, I developed it, you joke about my investigative skills. I've done public defense most of my career, you know, at some point or another, or pro bono. It's hard to get money for investigators, so I've learned how to do a lot of it on my own. And, you know, I dig a lot on things. So, and I do like to use the Open Records Act, so I was able to do that and get a lot of information. But what I did was I compiled all of the information Mr. Bradley gave me, and then I did various open records requests based on it. And then, you know, once I would get something, I would reach out to him to verify, because I wanted to make sure that I wasn't tracking anything that was wrong.
Yeah.
You know, I didn't want to make any allegations that didn't have support. So I would regularly verify with him, and I'd see him in court. We talked on the phone several times. I wasn't the only person that he told about this. There was another attorney on the case, Manny Aurora, who his client ultimately pled out, so he didn't continue this investigation, but he was involved in the investigation early on, and Mr. Bradley told him some of the same things that he told me. So, you know, I was able to independently verify a lot of things, which to me, investigating is important. You know, that the East Point location, that it was in Hateville. You know, Robin Yeardy actually did quit. You know, Mr. Bradley had told me about...
Was she forced to quit, or how'd that come about?
No, I don't believe she was forced to quit. That was a point of contention in our hearing. She said she left, that she was sent to another division. It's my understanding she had some... she was outspoken about she didn't like some of the things that was happening in that office, and when she voiced that, she was sent to a different department to work, and it wasn't something that she wanted to do, because she did the communications, and so she quit after that, is my understanding.
Okay.
Based on her testimony and, you know, the allegations and all the pleadings.
All right, so after, I might be skipping parts of your investigation because it's pretty darn thorough, and you had gotten this Trackhawk, Cellhawk, what's it called, where you were tracking the
Yes.
location. You were mentioning to me earlier when I kind of got you off that employees can have it on their own phone if they want to, and she could have gone back and proven that they had not been communicating before he was hired.
Yes.
Okay.
So let me explain that, because there's two different systems, and, you know, I'm always learning new things about this, but cell phone data is one of the new things in criminal defense. We see it in a lot of cases. The Cellhawk data that you just showed, that is geolocation data. That is different from the Cellbrite. So there's two different programs. Cellhawk is the program that does geolocation data. Essentially what you do is you get all of the pings. So every time your phone, you know, you see those cell phone towers everywhere. Every time you use your phone, it's trying to find the closest tower. So in a metro area like this, there's a lot of towers. That's why we get good signals. So when he's in Hateville, there's a lot of towers. So we can really, really narrow it down. So what we had our investigator do, and I'm only talking about the geolocation stuff, I'll talk about the text in a minute, but what we had our investigator do was narrow it down. We got all the raw data, and we had him narrow down, and we actually excluded a ton of things that were not right on top of this location. Like, we wanted to be very, very careful just to have what was literally right on top of this location. So he created a geolocation fence, which...
The location you're talking about is Miss Yeardy's condo?
Yes,
Okay.
It is Miss Yeardy's condo, that area. So he was able to find, essentially, just to summarize a couple of the things, where he, you know, Mr. Wade would call Miss Willis at midnight, something like that. And then all of a sudden, his phone would travel, and you can actually watch it. When you do the live Cellhawk, the app, it's pretty cool. You can actually watch the phone travel, and it's pinging because you're using it. You know, if you have an app open, your phone's pinging. So my phone's pinging right now because I'm sure I have an app open. So it's pinging from his house all the way down to the condo at midnight, 1 a.m. And he calls her when he gets there. And then it goes silent for 4 or 5 hours. And then, you know, early in the morning hours, he starts pinging again, driving back, and then he texts her when he gets home. So,
And this is before he gets hired in November of 21?
yes.
Okay.
So, and there's a couple different ones, and I would defer to the experts on the CellHawk data, but that's the summaries based on what we had him do. And again, we try to be very, very narrow. There were a lot of dates that it looked like it had happened also, but, maybe he was bouncing off a different location, and so we wanted to be very narrow.
So is that why y'all asked him in the hearing, how many times had you been to this I mean, you already kind of have the data on him?
Well, so that's an interesting point. All we have as defense lawyers is the right to subpoena evidence. I have to have an evidentiary hearing to do that. I could not issue a subpoena for AT&T for this evidence until I had a hearing date. So, and it takes a while to get this stuff. We got it that morning. So, the morning of the hearing, and obviously I'm kind of busy doing the hearing, we got that data. My paralegal was literally trying to download it for the investigator at the time and get it over. We knew we had the data, but we didn't know what it showed. So at that time, we didn't know, what it showed really until he was able to do the analysis. We had some preliminary reports from him, but nothing. I mean, it took a lot of hours. It's a lot of data. So it takes a lot of time to pinpoint this information. Yeah. But the other thing that I was talking about, so this is the CellHawk report, and heat map is just like how many times it's pinging, heavy concentration is, you're talking a lot at this time, or you're at that location a lot. There's a lot of usage. The other thing I was talking about, just to make sure it's clear, so that's CellHawk. Cellbrite is a different program. Cellbrite, and it's Cellbrite. Cellbrite is a program similar to CellHawk, but it downloads data in the phone. So, like, this one is you pinging off of towers. It's geolocation.
Showing where you were.
Exactly.
At a certain time.
Cellbrite actually can get your texts, your pictures, your app usage, I mean, all of that stuff. So it's one of those things that if you want, if a defendant is threatening someone by text and they delete it, they'll take their phone and hook it up to Cellbrite. Cellbrite it makes what's called a forensic copy of the phone, but you can also limit the data. So it's a very expensive program. So not a lot of people have it. So when I have my clients use it, it costs a lot of money for them to have it done. But the DA's office has it. They have the software. They pay for it. You can find that in their open checkbook. The city of Atlanta police have it as well. But what you can do is you can copy cell phone. So what I had mentioned earlier is
you have to have the cell phone to do that?
You do. You have to have the cell phone.
So what, did Mr. Bradley give you all his cell phone? Or
no.
How'd you get Mr. Wade's cell phone?
So we did not get that data from Mr. Wade. So we only got the geolocation data from Mr. Wade. We cannot, I do not have the power to get the text messages. I don't have that power. I would have to have a search warrant. The state's the only one that has the power to actually get someone's text messages out of their phone. But my whole point in saying that was if I had been accused of having an affair and it didn't start, and I said it started in April and someone else said it started in November, they have the ability, I don't have the ability, they have the ability to plug that phone into the Cellbrite and print out a report that shows all of the texts.
So Mr. Wade and Ms. Willis, had they wanted to disprove your allegations, could have just used that Cellbrite program and it would have shown no communications between them.
Yes, and it would have also showed the contents of the text. If the texts are romantic, if they're not romantic, if they're friendly, and they would control the data. So if there's something that was privileged, they could redact it. If there was something that, if they wanted to only limit it to, like, we want to prove that we weren't talking romantically in November, they could limit it to that.
So they could have actually pulled up the text itself to say, hey, I need you to help me work on this case, or else, hey, I need you to meet me at the Love Nest.
Yes, 100%, yes. I don't have that ability. So I don't have the ability to get a search warrant and get that data. All I have the ability to do is get that geofencing.
Well, who found out about these 12,000 texts and calls and all that kind of stuff?
That is what I was able to get by subpoena. So I was able to get the geolocation data by subpoena. What I can't get is what's inside of the phone. I can't get the texts inside the phone.
The words in the text.
Exactly.
But you were able to find out that they were texting each other prior to November 1st of 21.
Yes.
How did you find that data? Is that anything you've produced to us?
That is, so the CellHawk data actually analyzes that. So you can see, we just summarized 2021. So approximately 12,000 interactions, that's voice and texts for the year of 2021. And again, remember, 2021, he didn't get the contract until November of that year. So most of 2021, he's not under contract. Over 2,000 voice calls, almost 10,000 text messages.
How did they explain that? Did you confront, we're not privy to what all came out
Right.
in evidence at the hearings that you've had. Did you get either one of them to say, that's not true, we didn't really talk 12,000 times, or?
No, what they did was they filed an affidavit saying that geolocation data is not always reliable.
Okay. Does that apply to Cellbrite data, though?
No, it doesn't. And it was ironic because I have a number of cases. I mean, almost every murder case I've had in the last decade has had geolocation data.
Used by the prosecution against the defendant, right?
They use Cellhawk data. I mean, literally, they're using this right now. So our investigator actually analyzed the same, there's a trial going on, it's called the YSL trial. There's this same data being used in that trial, and our investigator actually analyzed it for them in that case. So, I mean.
For them, you mean for the Fulton County DA's office?
No, for the defense looking at that data. So the point is, they're currently using the same data in another courtroom to prosecute someone, but their defense in our case was that it's not reliable.
Okay, got it. And did your Cellbrite data come in? The existence of the cell phone calls?
No, so the Cellbrite data, that would have to be voluntary on part of the DA to actually
So they
voluntarily.
could show you that to disprove your allegations?
100%.
Okay, didn't do it?
No.
Neither Wade nor Willis?
No.
Okay. All right, so you've done your investigation. You've determined you think there was a relationship that had begun before he was hired.
Yes.
And after having met with Mr. Bradley, you began to prepare a motion to disqualify and to dismiss the case altogether, right?
Yes, I actually started the motion
Let me
in
get back on
September.
the cell phone.
and then added to
text
it.
messages. All right, and so then you somehow preserved, you had text communications with Mr. Bradley to confirm this?
Yes,
And was that because you didn't want to file a pleading that was inaccurate?
100%.
You wanted him to verify the accuracy of what you were claiming had happened?
I did not want to say one word that had not been verified.
Because he was the source.
Yes.
He's the guy that was his law partner and his divorce attorney,
Yes,
who probably knew as well as anybody in the state.
they had been best friends also.
Okay. All right, and so let's pull these up, Senator Dolezal. When did you start, you kept these text messages somehow?
I did. So I actually, Mr. Bradley uses a Android, I believe, and so it was not easy to just download them, and I'm not the most tech-savvy person. There's a lot of texts that just went into things that I thought would just embarrass people and weren't relevant. So what I did was I screenshotted the texts that I thought were relevant. I tried to use those in court, but the prosecutor kept objecting and saying I was hiding things because I wasn't showing all of my text. So they just kept on and on for days saying I was hiding things. And I explained to them, I let them look through my phone. They scrolled through all my texts.
Who's they?
It was Adam Abate was the prosecutor.
Okay.
So he just kept saying, that where's the beginning of that text? Where's the thing after that? Where's the other part of that text? These aren't complete, rule of completeness, kept objecting. And I had just screenshotted the texts that I thought were highly relevant, but weren't slanderous, I guess. I don't even know the word. But, there were some that Miss Willis's daughter had failed out. Like things like that. They were just ugly. They didn't need to be admitted.
Oh, yeah, I read that. We don't
I had
need to
just
go there.
so I had tried really hard to just screenshot the relevant ones, but they kept saying that I was hiding stuff and I wasn't showing the whole thing. So when they objected to my text coming in the screenshots, they said they wanted the whole text chain, and the judge ordered me to, if I was going to admit the text, to go figure out a way to download all of them. So I bought a program for $20, $30 and took 3 hours, and I was very proud of myself for finally figuring out how to do it. But I was able to make a copy of it and then redact our phone numbers. So this actually showed like when they're read, when they're viewed.
What were you, all right, so up there on January 5th at 9:50 a.m. You're asking, what do you, read the question.
So I'm asking him, do you think it started before she hired him?
You're talking about the affair.
Yes, the affair.
And what's his response?
His response was absolutely. It started when she left the DA's office and was judge in South Fulton. And so, these are things that he had told me, but I was getting ready to file. My filing deadline was the 8th. And as we're doing this, I'm fact-checking line by line, basically.
Right. So did you send him a copy of your proposed motion?
I did, and I actually admitted, so at the hearing that we had, I was able to admit the email where I sent him that. So I sent him a copy of the motion that weekend when I was I wanted him to review it, and then he had a text. He didn't write me back by email, but I submitted my email so that the court could see exactly when I sent it and when he responded, and then he responded that everything looked good. Because I asked, I said, I'm sending you this motion, I need you to look at it, and then he responded that everything looked good in it. Right. He actually told me at first he wanted me to make some changes because I had not included the information about how much money he had received. I had only included the information about how much Wade had received, and I didn't know that it wasn't really highly relevant to my motion, but he was like, oh, that's going to tip them off that I'm talking to you, and he did not want anybody to know that he was talking. He was very concerned about what
I'm going to let you just read through this chain.
Okay.
All right. We left off up there. Absolutely, it began before it began when she was a judge in South Fulton. When was she a judge in South Fulton?
She became a judge in August of 2019, and I did an open records. I first asked. I first did an open records, and they said no. So then I subpoenaed the records for the judicial conference, the municipal court conference.
So she was a municipal court judge.
They were both municipal court judges. So I got the.
Who's both? You mean Wade was the judge at the time also?
Wade was a judge. He was actually a speaker on the panel. It was October 2019. So I found online an old agenda where he was speaking, and Terrence Bradley had told me that they met at a conference where Wade was speaking and Willis had gone. So I knew that. So and it was in person. So I could narrow it down because of COVID. I figured out when COVID happened and when all the conferences went virtual. Narrowed down my timeline, so I searched for this specific time period, which is when Bradley had told me the relationship started.
And when was that conference?
It was October 2019. Right. So I found the agenda for that. So then I reached out to the municipal court judges CLE group and said, here's an open records request. I would like a list of attendees because I wanted to verify Miss Willis went there because I was trying to fact check. And they said no. So I subpoenaed them, and they gave it to me. I also subpoenaed.
Was she in attendance?
She was. Where
was that conference?
It was at Lake Lanier.
Okay.
I also did an open records request to the city of South Fulton because I know that they have to sign off if your judge is going to go to a conference. So I did an open records request to them to make sure that they had actually sent her to that. So I verified from two different sources that she attended that conference, and that matched what Mr. Bradley had told me.
All right. So is that a part-time job, a municipal court job, Judge?
Yes,
okay.
It is.
So Wade could continue practicing law and do that on the side?
So she was a full-time, but Wade is a part-time, and Wade only did maybe once or twice a month at most.
Okay.
Because he was in the city of Marietta. I mean, he was just he was a fill-in judge for that. That wasn't his.
Okay, so you narrowed it down to that's when the relationship began. Scroll through here for us, and I can't read that green line. What's
okay.
the next? If you don't mind, just sort of read us
No, of course.
through.
It says, "Is this accurate?" And this was again on
So when you're saying, "Is this accurate?" You're going over this brief and saying, "I'm about to swear this in court. Will you verify it's accurate?"
Yes.
Okay.
So at that time, I was going through the actual statement because I was trying to figure out how to say it, and so I said, upon information and belief, Willis and Wade met while both were serving as magistrate judges and began a romantic relationship at that time. And he corrected me and said, no, it was municipal court.
You had said magistrate court, and he said no.
Right.
Okay.
And I slipped up. I should have said municipal court. I knew that.
So you say thank you. What was his response after that? No, this is 12-something p.m. on January 5th as you're getting your pleading ready.
He said, you can't put where they met. Not many people know that. I might be one of only, not even Chris Campbell.
Chris Campbell was their other law partner?
Yes.
Okay.
And I did not disclose Mr. Bradley in my initial filing. I didn't until the state forced me to.
Why was he afraid to be disclosed? Just because of his relationship with Wade, or was he afraid of these people, or just didn't want to betray them, or what?
Multiple reasons. I mean, it's the district attorney in Fulton County. I didn't really want to go, file something against her. It's not exactly a fun position to be in. Also, I mean, they have a lot of mutual friends. I'm sure it wasn't a fun position to be in to be outing a friend of yours, But the attacks, I mean, it's a small legal community.
Were you able to get this into court? Because Bradley, I saw some of his testimony, all of a sudden can't remember anything about anything now. Were you able to use this to impeach him and show that he did know precisely what happened and when?
Yes, and he changed his testimony somewhat. At first, when he first testified, he testified that he had never discussed this with me. And
Then you showed his text messages where y'all discussed it.
well, at that point, that caught me off guard. So, I didn't expect that. So then I pulled my text messages, and I'd had some screenshots of them just in case. And I told his lawyer, do you want to look at my text messages? And so then he later came back and testified that yes, he had.
Had told you that?
Yes.
Okay. And did Wade testify at any of these hearings?
He did.
Did he acknowledge the relationship or not
He acknowledged the relationship, yes.
before he was hired?
No, he did not. So before I filed the motion, nobody acknowledged any relationship. So I filed the motion on January 8th, and then on Martin Luther
Yeah,
King.
walk us through that. What were the grounds why is it you feel like Fonnie Willis should be disqualified from continuing this prosecution?
Yeah, and these are things that I alleged in my initial motion that was filed on January 8th. I outlined this. My client in particular was not part of the special purpose grand jury. They did not recommend him to be indicted. He was not a subject. He wasn't part of that. So he was added on.
That's interesting, because I remember hearing that the special grand jury had recommended prosecuting like 40-something people.
They had.
He
yes.
was not even in that list of 40?
He was not.
And they didn't take, or they, as in Fonnie Willis, did not take the advice of her own special grand jury as to more than half the people they wanted prosecuted.
Subsequently, there's been a book that was published that called Find Me the Votes, that authors had exclusive access to her, and so all of her theories in how to indict people and who to indict was explored in that book. So from that, I was able to learn that she cut a lot of people. I
Was that because they cut deals with them, immunity deals, or?
Some of them were that. Some of them I just don't think she wanted to bother with.
Then she added to the list, though, people that were not even recommended, or
My
at least your client.
My client, yes,
Okay.
she added him. So he was one of the ones. So there were some people, and it's publicly available in that book, like Senator Graham, Loeffler, those Perdue, those people.
They recommended prosecuting them?
Right. She had considered prosecuting them and taking them off the list. So there were a lot of people that had been on the consideration and then had been removed. And my client had not been considered, and then he was added. So to me, I was trying to figure out, why would you want to expand it? There's different ways you can go about prosecution.
Did you figure out why they add your client to the list?
No, but my allegation in my motion is that the bigger the case is, the more money that's made, and that made sense to me. So for me to file the motion to disqualify, obviously, we had to have some type of a basis, besides all of the violations, and so expanding the litigation. Because of how large it is, the judge has said we're probably going to have 3 trials, and each of them is going to take several months. Where if you just imagine, just follow me down the path, if you only indicted one person and it was narrow, you could try it in a month. If you indict 19 people and, 3 different essentially alleged criminal schemes, like I divided it up earlier, that you now have 3 years of trial. You've now gone from a month of trial to 3 years of trial. That's a lot more money. And so that, to me, was a financial motive, particularly since my client was not recommended by the special purpose grand jury to be indicted.
And you had the data to show that she was financially benefiting from the continued prosecution?
Yes. And so to answer your question, you were saying walk me through it. So January 8th, I have a deadline to file this. So I'm verifying, and that's what you can see in the text. You can see heavy text with Mr. Bradley right around then to verify everything. I file it, and at that point, the world is shocked. I mean, shocked, because nobody had any idea. This had been hidden. This was even hidden from her father, who she had testified she talks to 10 times a day. So very few people knew about this relationship. And so they very much wanted to know who knew about it. Mr. Bradley, that next weekend, he gets some calls about, he gets a call, trying to fish to see if he's the leak, is what it was couched as. He gets a call from a gentleman named Gabe Banks, who ultimately represented Chris Campbell he filed a motion to quash against Chris Campbell, who's the law partner.
Gabe Banks' wife works for the DA's office?
Yes, he does. She does.
Works for Fonnie Willis?
Yes, and I have not gotten it. I've not open records it, but I have been told that Mr. Banks also has one of these special counsel contracts. Again, I have not open records that, not part of my case. But so he calls Mr. Bradley, and Mr. Bradley calls me and another friend of ours. Her name's Cindy Yeager. She's a district attorney in Cobb County. And, he was upset. I talked to him. It was, I believe, a Saturday night, and I could tell he was upset by his text. I left my kids and went and talked to him because I was worried about him. And, he took it as what he described to me as the first shot against the bow, that they were trying to figure out if it was him, and they were trying to silence him.
Trying to silence him.
Mm-hmm. And he said Gabe didn't say anything that threatened him. He just out of the blue called him, and he hadn't talked to him in quite some time. So it was out of the norm for him to call. So Mr. Banks called and told him that was asking if he was the leak, meaning if he was my source. And Mr. Banks said that it was because he had seen a news article, and Mr. Bradley knew that wasn't the case, so he said, send me the news article. So he sent him some article that did not say he was the leak, and that put an end to it. But then the next day, Mr. Wade called Mr. Bradley's best friend and said to call, he didn't call Mr. Bradley directly, but told his friend to call Mr. Bradley and remind him of his privilege.
It's an attorney-client privilege.
Yes.
Who's the best friend? Can you tell me?
I'm not, he told me his name, and I'm not positive. I think I know who it is, but I'm not positive.
All right. So Wade calls Bradley's best friend, says, you better call Bradley, remind him he's got attorney-client privilege with me, and he better not spill the beans.
I do know the best friend works at a law firm called Beasley Allen. He told me that. He said his best friend's name, and then he said he works at Beasley Allen. And he was pretty upset about it, and it was the same day of Miss Yeager's birthday, so he didn't want to call Cindy, but he was upset, so he called me, and we talked about it, and we were both pretty upset about it, because it seemed, why...
Tampering with witnesses.
It just seemed like tampering, and it's just, it's just an uncomfortable position to be in, and all of us were kind of worried how the state would react to all of this. But at that point, it's
Did
still...
he interpret that as Miss Willis trying to intimidate him from revealing this affair?
Or Mr. Wade.
Okay.
He took it as intimidation, yes.
Right.
Because what he called it as is the second shot across the bow. Those were his words. So he said first shot across the bow was Gabe Banks, second shot across the bow was Nathan Wade calling.
Okay.
So that's how he interpreted it. But at that point, I had not disclosed him as the witness, as the primary source. So nobody knew that, and I was trying to protect him as much as possible, just because I knew he didn't want these calls. It's not something that you want. So they filed some motions to quash, and I had to
Quash what?
To quash all of the subpoenas, pretty much every subpoena that I had issued.
So after you filed this motion to disqualify, I guess a hearing was scheduled?
Yes.
And
yes.
then you started issuing subpoenas to line up your evidence?
Yes.
That's when this witness tampering occurred?
Yes.
After that, to try to intimidate your witnesses from coming to court?
Yes. So, and let me walk through the timeline. So I filed this on the 8th. The next thing that happened was Ms. Willis testified. I say testified. She spoke at a church on Martin Luther King Sunday and was making some statements about why did they single out Mr. Wade. Didn't say anything about that we singled him out because he's the only one she's having an affair with. Did not agree to that. Instead said that it was racially motivated.
And the other two special prosecutors were white.
Yes.
But they were making significantly less money.
Right. And she even said, to the church, she even said that I'm paying them the same rate, which is not true. Mr. Floyd's contract is for $150 an hour. It's never been $250 an hour. So that, one of my kids was listening to it and, said, come listen to this. And I listened to it and I was like, wait, that's not true. So that was one thing that she said that wasn't true. Also that it was racially motivated. She didn't say anything about, yeah, they're singling him out because he's the one I went on all these vacations with and he's the one I'm romantically involved in. Instead, she said that we were singling him out because of race. And then she said that they were all paid the same, which is not true. So I thought at that point, okay, they're not going to admit that they have this relationship. And so I'm texting with Mr. Bradley, oh my gosh, are they going to lie about this? Like, it's on their credit cards. Like, I don't know what's going to happen here. And so then in the divorce proceedings, Ms. Willis had been subpoenaed to testify, and she actually invoked her executive privilege as the DA.
That. She wouldn't testify.
She would not testify. So then...
And then they settled it.
Right, and then they settled it. Because the judge said he was going to have to testify. So they settled it, and he did not have to testify. So at that point, the judge had given us a hearing date, so I was able to issue subpoenas. So my subpoenas started going, and I filed the returns of the subpoenas, and all of a sudden the motions to quash started coming in. Right around that time, the state filed their response where they admitted to this relationship, but they put limits on it. So their response that they filed I believe it was the 2nd, February 2nd, I believe. They, yeah, February 2nd. So on February 2nd, they filed their opposition to our motion. They admit that there was a romantic relationship, but they claim that it started after he was hired and that all of the gifts and travel was roughly divided. They submit an affidavit from Mr. Wade, and they submitted a receipt from a credit card where she had paid for one plane ticket. So, you know, it was a couple $100s on hers and then thousands of dollars on his. So then my subpoenas were filed, and every single one of them had a motion to quash. And they kept saying, I don't have a good faith basis, I don't have a good faith basis, kept very harshly saying that I was making this up and nobody had told me this and it was, you know, gossip and I was lying and I should be sanctioned. So the court held a hearing on their motions to quash, and I was forced to disclose Mr. Bradley as a witness, which I did not want to do because I was worried, because I knew they had called and all of these things, but I had to disclose him as a witness. And so at that point, I was still talking with Mr. Bradley fairly regularly, but that then changed.
Okay. So you're waiting on the judge to rule on your motion to disqualify?
Yes, sir.
In summation, the grounds for that are what? That this is improper for a prosecutor to have a relationship with the special prosecutor?
Yes, it is a conflict of interest.
Okay. And that's because the financial benefits or just because?
Mainly the financial benefits. There's a couple different aspects to it. We've also alleged some other misconduct because the prosecutors aren't allowed to publicly condemn an accused prior to trial. And she made a speech at a church and said this was racially motivated, talked extensively about the clients being guilty. She testified at our hearing that our clients were guilty, that my client was, you know, guilty of trying to, I don't even remember, subvert democracy or something. But she's made a number of public statements condemning their guilt, which is not allowed.
That's inappropriate conduct for a prosecutor? Very
much so. And there's case law on that. There's bar rules on that. So there were a lot of public speeches that were made along the way. And, you know, you can kind of follow them through this media monitoring company. But so she makes these, and then she got disqualified from prosecuting another person she wanted to prosecute.
For making public statements?
It was for a fundraising. She had thrown a fundraiser for his opponent, his political opponent.
Right.
So when that happened, you sort of see her press stuff dwindle a little bit. So she stopped making as many public comments. But then when this motion came about, she made the church speech, as I'd call it, where she's, you know, calls me and, you know, my client racist, and says, condemns their guilt. And then she also gave interviews to this book. I don't know, the timing was just, it was just nuts. But the book came out right around the time that all this was happening, and it's called Find Me the Votes. And
that came out in 2024, you're saying?
It came out. It came out a month ago, if even. And she literally let the authors of this book in when she was deciding how to prosecute this case, who to indict, who not to indict. I mean, their whole thing is that they had unfettered, you know, behind-the-scenes access to her thought process and stuff. So, and she's talking about all of this, you know, that they're guilty. But the big thing for the forensic misconduct is she's in the church speech, she's saying, and she says this in the book too, that God has told her to prosecute them. So the theme between these two things is that God told her to do this, and that she is doing the will of God by prosecuting our clients. And that is...
Okay. That's unethical.
In my opinion.
All right, so there was, I'm trying to recollect what I remember reading in basically the Atlanta newspapers about all this, because this was new to the state Senate as well, because all of this began on January 8th, which is that the day we started, 8th or 10th or something?
It did, and no,
I mean, it was the day session began, and all of a sudden these bombshell allegations come out, and I think that was the motivation for our Senate resolution forming this investigative committee to say, let's find out if this is true, independently of all you guys' legal issues or whatnot. So I remember she wouldn't testify in the divorce case.
Right.
But did you subpoena her to testify in your motion to disqualify?
Yes, and she filed a motion to quash.
She refused to testify, but then she came to court and did testify?
Yes.
Okay. And in that...
As they were arguing the motion to quash.
I wonder, okay, so in that testimony, did she deny the start date of this affair?
Yes, she said it started in early of 2022. There was some discrepancy between them, a month or two here and there, whether it started, generally it was around March, is what Mr. Wade
So
and Ms.
what are the
Willis.
consequences for an attorney to give sworn testimony that she did if you're Bradley, what is it, Yerke? Yerty, your Trackhawk data, your other independent verifications are found to be truthful?
It's a crime. It's a felony. You'd lose your license.
Okay.
It's perjury.
Same for Wade.
Yes. And we have rules that are one of the, outside of privilege and confidentiality, we cannot suborn perjury. So if I have a client who tells me I did it, I can't put them on the stand to say I didn't do it.
Okay.
I would lose my license over that. I cannot do that.
And Yerty came to court and said, oh yeah, this started in 2019.
She saw them, she saw them together. She testified that she saw them romantically together, and, they were very close.
Yeah. And you had Bradley's text message that showed he confirmed that absolutely back in January.
Yes, and he had a lot of details, little details that matched up.
Did you get other details from him by phone?
Yes.
That wasn't in the text? What did he?
A garage door opener that Mr. Wade had a garage door opener, and then I've subsequently learned that he told Mr. Aurora the same thing.
Garage door opener to her place?
To her place.
Okay.
Mm-hmm. Yeah, to her place. There were other things, just a lot of context, things about how freely Mr. Wade could go in and out of the office, the DA's office, stuff about that they would sometimes use hotels. One thing that he told me was that Mr. Wade had, before he filed for divorce, had used Mr. Bradley's credit card and then paid him back in cash so that there wouldn't be a record of it.
Okay. All right, so I'm a little puzzled by the legal standard. I'm reading the newspaper articles that explain to us the difference between a conflict of interest and an appearance of a conflict or an appearance of impropriety.
That is the big argument right now, and I'm not the best person to explain that. My husband argued that part, but appearance of impropriety, it's one of those things like that if it undermines the outcome, undermines the confidence in the outcome. And we spent a lot of time in our brief talking about the constitutional underpinnings of this. Due process, that my client has a right to due process. He has a right to a fair and impartial prosecutor, and we don't think that's happened in this case. And so I think that would be more along the lines of the appearance of impropriety, and then actual impropriety is receiving money, like receiving money and not paying it back. And there was testimony about that. Ms. Willis came in and testified, and Mr. Wade did, that she paid him back in these sums of cash, but there's no records of any of that or where she got it.
Anything shows him depositing cash or
no,
receiving cash?
No, and we asked her like where you got it. She said that she said she borrowed it from her campaign. So, she said the original large sum of cash came from her campaign.
I think all of us up here that have campaigns know you can't take campaign funds for personal use, right?
I'm not well versed in that area of law, but that is my understanding.
It's pretty black and white.
So she testified that she took that the majority of the cash she had on hand was from her campaign, that a loan she had given herself from the campaign. She was very clear about that. And then she also said that when it got low, she would supplement it by getting like $50 back at Publix. But she's giving him, $4,000, $2,500, so, large sums of cash. So, and there's no trail, obviously. There's no record of any of that.
Right. In some of the documents you produced to us, there were a couple of IOLTA trust accounts. Mm-hmm. Those were Mr. Wade's accounts?
Yes.
Okay. So he had more than one trust account in his law firm?
Yes, he did.
And did you find any discrepancy or whether these funds were deposited there?
Yes, and so he testified because we asked him where he deposited the funds.
And these are the funds where his paychecks basically from Fulton DA's office?
Yes.
Okay.
At first, he deposited them to his joint IOLTA that he had with his law partners, and then he started depositing them to his when I say personal, just him IOLTA, an IOLTA that did not have anything to do with Mr. Bradley or Mr. Campbell.
Do you think Mr. Bradley was aware that he was running the money through a separate account,
I think it might have been part of the reason that they dissolved.
that they broke up?
Yes.
Do you think his ex-wife knew that this money was being held in a trust account rather than previously it had been going through his own bank account?
His ex-wife didn't have any idea. I mean, you could tell from the pleadings that he was even making this much money. I mean, he filed some interrogatories and some answers in that divorce case saying that he made a couple $1,000s a month. I mean, very, very minimal amounts.
Well, we knew he was making up to $35,000 a month under this contract.
Right, and he has a lot of money parked in one of those IOLTAs that's not disclosed in the divorce.
Okay. So that's, does it look like he was using his law firm trust account or his personal lawyer? IOLTA is a legal trust account, right?
Yes.
The interest from it goes to the state bar to help fund some
Yes.
indigent care or whatever, right?
Yes. As much as I wish we could park money in our IOLTAs that was earned and not pay ourselves, we can't do that. So when you earn money, you can't leave it in your IOLTA. IOLTAs are for client money, so they're a lawyer trust account, and essentially what they are is like if you settle a divorce case, not a divorce case, I'm sorry, you settle a civil rights case or a
Personal injury case.
Personal injury case,
Right.
and you get $100,000, and 60 of that's the clients and 40 of it's the lawyers. It has to go into your IOLTA. It sits there until you clear the case out. You know, you've settled, you finalize the case, you send a settlement letter, you get the amount, and you have to put it in your actual business account, and then the client gets their check for their part. So IOLTAs are very highly regulated by the state bar. They can't commingle funds. It can't be earned money. It's got to be money that's not earned. And the interest does go to the state bar, but once you earn the money, you have to pay it. You have to have it in your account because you have to claim it on your taxes.
Right.
I mean, lawyers wish that they could keep money in IOLTAs and not have to pay taxes on it until it was a year that
All right. So sometimes
financially they wanted to.
attorneys may take a retainer
Yes.
up front and bill against that retainer. Say, you might do that on some of your criminal cases. So, yeah,
Yes.
I'm gonna take $25,000, I'm gonna put it in my trust, and then I'll submit an itemized statement and pay myself as I earn the money.
That's exactly what they do with retainers that are refundable. So they would ask, $10,000 retainer, and then if this month I billed $1,500, I send you a bill, and then I take the $1,500 and I transfer it to my business account.
Okay.
As soon as it's earned, you have to transfer it.
So these funds, if they in fact came from the contract with Fulton County, should probably never been put in a trust account at all because they were already earned after he had done the work, and within some amount of time after that he sent the bill and he got paid for work that had already been done.
I mean, if they were put in a trust account, they would need to be transferred quickly.
Is that the kind of
I don't do that, but
ethical violation that can get you disbarred?
they highly regulate the IOLTAs, highly regulate. I mean, the state bar, like there's a list of places that we can do banking because they're regulated by the state bar. I have to go in person for most of my IOLTA transfers. They're not something that I can do like online banking. I mean, it's a pain.
Okay.
But yeah, so they're highly regulated, and we know these were deposited in his IOLTAs because the back of the checks for Fulton County show where they were deposited.
And have you asked him about this? Has he given any explanation for why he ran this money through a trust account, or is it still in there? We don't.
I mean, the last I knew, he didn't give any explanation. I mean, he just said that he pays for everything through his business, and then he basically just said his accountant figures it all out.
Okay. I know you have a court appearance this afternoon. You've been
Yes.
very patient with us. I'm going to give Senator Harold Jones an opportunity to ask a few questions. Under our rules, we do allow at least one member of the minority party to participate. And Senator Jones, you're not time limited. If you, when the buzzer hits and you've got to go to court, you
Okay.
tell us, but I feel like we got at least 15, 20
You
minutes or
definitely
whatever.
do, and I'm happy to answer any questions you have. My court's at 115 in Fulton County, so, if I...
So that line of question deals specifically with the legal principles involved in your motion to disqualify. As I understand it, you're not really claiming a conflict of interest between defendants, et cetera. It's the conduct of the prosecutor.
Yes.
That
Yeah, there's
is
no
improper
conflict.
conduct.
Yeah, we're not
Okay.
talking about the conflict between defendants.
We're talking about the fact that the DA's office failed to follow state law and get an approval, failed to follow county policies to get approval of her budget and this contract, that he was not eligible to have been hired had he been disclosed because of, you referred to it as nepotism, but it's relationships
Yes.
with, and complaints are of she's receiving a financial benefit of gifts of more than $100, which violate county policies.
Yes, county and state. So, and we attached that to one of the briefs, her return where she filed it under oath that says,
Okay.
I mean, it specifically says if you've got something over $100, you have to disclose it.
And
Oh, here
then-
it is. It's, so it's called the Fulton County Income and Financial Disclosure Report. And that says, and it says pursuant to Section 2-79 of the Fulton County Code of Ethics, that anytime you've got each gift or favor from a single prohibited source in the aggregate amount of $100 or more. And then it says, for purposes of this section, gift and favors means anything of value given by or received from a prohibited source. Prohibited source means any person, business, or entity that the involved officer, so Ms. Willis, knows or should know is seeking official action or seeking to do or doing business with the county. So obviously that would apply.
Okay. And failing to respond to your open records request and potentially giving false testimony under oath if your version of facts is proven to be true.
Yes.
Okay. Keep us posted. I guess we'll keep reading the press as to how your case progresses, I guess there. I'm troubled about this Find the Votes book. Are you saying that the prosecutor has been discussing an ongoing prosecution and her prosecutorial strategy and indictment strategy to authors of a book during the course of the prosecution?
Yes.
And
yes.
that book is now come out?
It is. It's.
And
I don't think I brought it with me. No, I have a copy. We admitted a copy at the hearing. No, it's out there. It was published. You know.
Is that a violation of ethical obligations in some way to be publicly discussing, just like the public statements you made about the guilt of a defendant, et cetera?
Yes, definitely. And we alleged that and argued that as far as forensic misconduct. It's very surprising, shocking, and I don't know that there's a ton of cases on it. But that book, also, we talked about it somewhat in our hearing because it goes into a lot of details about the financial troubles that Ms. Willis had prior to becoming DA. And so, it talks about that a lot.
Okay. Is she getting a financial benefit from that book?
I don't know.
Is she getting a royalty or a payment for having been a contributor to it?
I have no idea.
Okay.
But I know her dad testified that he was interviewed for it. He came to the district attorney's office and was interviewed for it as well. And I think that was when her dad first learned that she had dated Mr. Wade, I think. But I may be wrong. Or maybe that's the first time they met, something like that.
All right. Well, thank you for your willingness to testify before us, and the documents you provided. We'll need some time to analyze and review those. And again, all committee members have access to those. At David Cook's office, he's got them literally locked up in a room. We are not making copies or disseminating those. I will review the documents in more detail, and I'll confer with you, Senator Jones, if you're able to. We might can agree on what should be kept confidential there. I noticed some bank records and things that if it were me being investigated, I probably wouldn't want it divulged to the public. I don't think that's necessary for us to do our job here. I do appreciate everybody's attendance, and thank you all for making time to be here on our committee day. We'll keep you posted further meetings. The meeting is adjourned.